Day one of the Esidimeni tragedy arbitration kicked off with a stern warning from former Deputy Chief Justice Dikgang Motseneke to lawyers saying that the aim of these sessions are not about being combative, but rather about getting to the truth as soon as possible. Motseneke made the comments after a dispute over who will be called to testify during the arbitration. Lobby Group Section 27 has raised their concern about why the state had not called former Health MEC Qedani Mahlangu to testify at the Esidimeni tragedy arbitration. The arbitration process was initially prescribed by Health Ombudsman, and other parties who released a report onto the death of mental patients moved to several NGOs, mainly unlicensed, across the province of Gauteng.
Not be seen to be in a combative mode, trying to battle it out, as it will not be ideal. The outcome of these proceedings should be a win-win situation for everyone. There shouldn't be a winner, there shouldn't be a loser. The government, having taken responsibility, comes to these proceedings willing to divulge as much information as possible in order to assist and facilitate this process.
There isn't anybody on this list of government witnesses that was actually involved and present at the time that this happened. And at the very least, we would have expected that the former MEC for Health, Ms. Mahlangu, would be first of all, present throughout the proceedings in order to hear the testimony of the families and then to respond thereafter.
Well, let's now cross live to Parktown, where the Esidimeni hearings are currently underway.
Kukhona inqubomgomo noma uhlaka lwenqubomgomo lokususwa kwabantu ke kuzikhungo zokunakekelwa kwabalabo bantu ke abaphethwe izifo zengqondo kanti ke loluhlaka ke lwenqubomgomo ka 2013 ukuya ku 2020 ukuthi ke kususwe labantu kuye kwatholakala ukuthi ke kuye wasetshenziswa lenqubomgomo kungakabhekelelwa ke amalungiselelo anele kanti ke futhi ke ukuya ngemibono yezingcwethi ukuthi ke lokho ke kwenze noma ke lokho ke kuholela ekutheni labantu ke noma ke abagulayo ngokwenqondo ngesinye isikhathi ke bagcine ke sebasejele noma ke kuba khona ke ezinye izehlakalo ngendaba yokuthi ke bokungekho malungiselelo anele nokuthi ke lesi sinqumo sona kubonakala ngathi ke siye sathathwa ngokuphuthuma kanti ke futhi ke bangabukisisi izimvo zezingcwethi.
Die tweede rede hiervoor is die beleid wat die nie instansies sorg op die wegbeweging van instansies sorg. Dit is die nasionale geestesgesondheidsorgbeleid, ekskuus, ek het nie die hele term daar gekry nie, van 2013 tot en met 2020. Hierdie beleidsraamwerk sê dat nie instansiegebaseerde sorg het verhoog sonder die nodige ontwikkeling van gemeenskapsgebaseerde sorg. Dit veroorsaak dat persone wat aan geestesgestremdhede ly, nou op straat is, in die tronk is en sê die verslag ook dat die gemeenskapgebaseerde sorg sal eers uitgebrei moet word en bestee moet word voordat die wegbeweeg van psigiatriese hospitale af kan plaasvind.
Council, I have to ask, how long more do you have? I don't want to restrict you at all. It's just basically to arrange time.
It's hard to calculate with the interpretation as well, but I've got about a page and a third, 1 1/3 pages to go.
I think we're going to go and finish that, and then take the lunch adjournment then, and then go to the other submissions. After that, we are at 1:15, so we should be good to go. If any of you is particularly hungry, just raise your hand. I'll
try to present more quickly.
Okay, thank you. Okay.
Thank you. So, what about the rights and interests of the mental health care users in this framework? The expert opinion of Ms. Coralie Trotter, who will testify during these hearings, tells us that all available psychological, psychiatric, and medical knowledge regarding the factors to be taken into account when relocating institutionalized patients was ignored. This resulted in fear, confusion, trauma, and a sense of homelessness by the mental health care users. According to Ms. Trotter and her team, what makes it worse is that families were not told where their loved ones were being sent, which meant that the mental health care users did not have the benefit of the comfort and reassurance and stability of the family once they were moved.
Khuluma ke ngokuthi ke uma sesibukisisa ke amalungelo nentshiseko ke zalabo ke abasebenzisa ke izinsiza zokunakekelwa kulabo ke abagula ke ngesifo senqondo kanti kuyakhomba futhi ukuthi ke kuye kwashaya indiva ubufakazi obathule izingcwethi ke zokuthi ke lokhu ke kuye kwaba kwathinta kakhulu ke izigulani ngendaba yokuthi ke bona ke bayabaqhubeka ukuthi basebenzise leso sinqumo njengoba sithethwe benganaki lokho kuxwayiswa noma isexwayiswa basinikezwe ke izingcwethi maqondana ke nohlaziyo abalenzile.
Wat van die regte van hierdie pasiënte in hierdie raamwerk? Soos mevrou Trotter sal getuig en sy sê dat alle sielkundige, psigiatries of mediese kennis wat gepaard gaan het met hierdie oorplasing was geïgnoreer. Hierdie pasiënte het gelei aan trauma, vrees en die gevoel van haweloosheid. En wat dit erger maak is dat die families nie gesê is nie. So hierdie pasiënte kon nie vertroos word deur hulle families of verseker word deur hulle families deur hierdie oorplasing nie.
Thank you.
Counsel?
So regarding the psychological and medical knowledge that the experts refer to, even if those in government responsible for the health and well-being of mental health care users who are in state care, even if they were not aware of this knowledge and the risks associated with the relocation, they were informed in detail by Dr. Talatala from SASOP, who cautioned them of the potential harm and who wrote to the department no less than 5 times between March 2015 and October 2015. Ultimately, SASOP, together with SADAG and the South African Federation for Mental Health and the Association of Concerned Family Members of Residents of Life Esidimeni, had to bring an urgent court application. The matter was settled out of court the day before the hearing. The agreement that was reflected in the settlement was an undertaking by the department to engage in a meaningful consultation process with the patients and their families in order to ensure a safe and orderly transfer that would not jeopardize the rights of the patients. As we now know, the department reneged on that agreement. As a matter of law and constitutional rights, mental health care users are equally entitled to the protection of their rights to administrative justice, dignity, access to health services, the right to an environment that is not harmful to their health and well-being, freedom and security of their person, and the right to life. Any steps taken by the department in relation to the provision of mental health care services must also prioritize the needs of mental health care users.
Day 1 of the Esidimeni tragedy arbitration currently happening. We heard earlier today a stern warning from former Deputy Chief Justice Dikgang Moseneke to the lawyers, saying that the aim of the session is not about being combative, but rather about getting the truth as soon as possible. Submissions being made there with regards to the treatment of those patients and also their rights, and also the rights of their families. Talk around the families not being better informed or well enough informed with regards to where these patients were being moved at the time. But stay tuned to ANN7. We will be engaging with our reporter a little bit later to get the latest details and developments here.